So we are starting a new chapter right now. This is going to be the chapter called Bush Sr. and Clinton. Okay. Today's video, the first video, is going to start out with us covering several court cases. So here we go. We have Engel versus Vitale, 1962. It is unconstitutional for state officials to compose an official school prayer and to encourage its recitation in a public school. So your school cannot force you to pray. That's basically what it's saying. It also basically says that school officials like teachers or principals cannot lead a prayer. So it's totally legal for you as a student to lead prayer and to come up with a prayer for everybody else to say. That's all okay. All right, we got Gideon versus Wainwright, which is more likely to be on your LEAP test than Engel versus Vitale. 1963, state courts are required under the 14th Amendment to provide counsel in criminal cases to represent defendants who are unable to pay their attorney. This goes along with Miranda versus Arizona, which we'll be teaching you shortly. Basically, you know your Miranda rights, the rights the cops read you whenever you get arrested, okay? This is part of those Miranda rights. It says that if you are unable to pay for an attorney, one will be provided for you by the state. Now, the reason for this is obvious. What was going on is basically people that were poor were getting arrested and they didn't know they had the right to legal counsel according to the Constitution. So now the government has to pay for your lawyer if you cannot pay for your own. All right, we got a court case question here. Gideon versus Wainwright. The Supreme Court decision in Gideon versus Wainwright established the defendant's right to legal counsel. This decision had the effect of what? Okay, what was the effect of it? It expanded the legal rights of lower income Americans. That is the correct answer. Okay? All right, a couple more cases. Escondido versus Illinois, 1964. Criminal suspects have the right to counsel during police interrogation under the Sixth Amendment. Again, going back to Miranda versus Arizona, you have the right to have a lawyer present whenever you are being questioned by the police. If you waive that right, if you tell the cops, I'll talk to you anyway, then anything that you say can and will be used against you in a court of law. So this goes along with Miranda versus Arizona as well. New York Times versus Sullivan, 1964, established that the actual malice standard, which has to be met before press reports can be considered as libel. Libel means that you are lying in print, okay? So basically what they're saying is malice, that means ill will. So basically if you say something in print that's not actually true, but you didn't mean to hurt the person's reputation, then that means that you actually are not violating this, okay? So if you are trying to lie to maliciously, that's the word malice, to maliciously in somebody's reputation or damage their reputation, then you are legally liable and you can be sued for libel, okay? It's considered a key decision in supporting freedom of the press and allows free reporting of the civil rights campaign in the South. Reynolds versus Sims, 1964. The state legislature districts had to be roughly equal in population, creating the one man, one vote rule. So in our country, we have voting districts in each state, okay? Each one of those districts has a congressman that represents them in Washington, D.C. And what they're basically saying is that the size of the districts need to be redrawn periodically. So that way, if there's 500,000 people in this district, then there should be 500,000 roughly in the district right next to it, and the district next to that should have another 500,000. So you can't have one district with 500,000 people and another district with 20,000 people, because those 20,000 people are more powerful in their representation in Congress than the 500,000 people. So one man, one vote. That's Reynolds versus Sims. Now we come to the big one, folks. Okay, this one is one of the big 5 LEAP questions. Okay, big 5 court cases on the LEAP test, I should say. There are 5 5 court cases you must know every detail to. We got Plessy versus Ferguson. We have the Scopes trial. We have Brown versus Board of Education of Topeka, Kansas. We have Miranda versus Arizona. And then we have Roe versus Wade, which we discussed last chapter, I believe. So, Miranda versus Arizona says statements made by a defendant in police custody can be admissible only if the prosecutor can show that the defendant was informed of his right to counsel before questioning. So what happened was there was an illegal immigrant named Ernesto Miranda, okay? And he was in Arizona, and he went out one night after a day of work, and he got really drunk. And he started hitting on this pretty lady that was at the bar. And the lady said no multiple times. She said no over and over again. And so Ernesto Miranda, he waited out in the parking lot, and when the lady came out, he grabbed her and he put her in his truck, and he took her down the road and he raped her. And then he dropped her off. Well, the cops come and they arrest Ernesto Miranda, and they tell Ernesto that you're not leaving this room until you confess. You must confess to the crime of rape here. No bathroom breaks, nothing to drink, nothing like that until you confess. So he confessed. He said that he raped the lady, and then they arrested him, right? Well, the thing was, his lawyer came by the next day and said, why didn't you wait for me? Why didn't you wait for counsel? Why did you confess? And Miranda said, well, they told me I had to. And so he brought that up in court, the lawyer did, and the court case was thrown out. Ernesto Miranda was allowed to go free, even though he was 100% guilty of the crime of rape, because he had not been informed of his right to remain silent by the police officers. If you think that story's terrible, it is, but the thing is, Ernesto Miranda, later on, a couple of years later, after he got out, he was at a bar, and he ended up getting drunk, and he ended up getting in a fight with somebody else, and that person pulled out a knife and stabbed Ernesto Miranda to death. So he got what he deserved in the end. Okay, so because of the Miranda versus Arizona case, we have your Miranda rights, and I'm sure you know them. You can say them along with me if you want. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have a right to an attorney. If you cannot afford one, then one will be provided to you by the state. And that's pretty much the end of the Miranda rights. All right, our next one is going to be Griswold versus Connecticut. The Constitution protects the right of privacy, okay? That's in our basic Constitution. This case involved a law that outlawed contraceptives and becomes key to Roe versus Wade. So in this case, contraceptives or birth control were a brand new thing, okay? And the hard Christian right was fighting it, especially Catholics. They did not want birth control. They thought it was a sin to have birth control. And so what the Supreme Court ruled in this case is that it is the woman's right to privacy in the matter that trumps everything else, that is above everything else. So the only person a woman has to tell whether or not she's on birth control is her doctor, not her husband, her boyfriend, her daddy, none of that stuff. They have the right to privacy. That logic is going to later on be used in Roe versus Wade, which we are going to discuss very soon. 1969, Tinker versus Des Moines defines First Amendment constitutional rights in schools. So your First Amendment is your right to freedom of speech, freedom of the press, and many other, 3 others. But anyway, so what happened was there was this group of students during the Vietnam War that...
Miss Turley, call the office.
Sorry. There was this group of students in the Vietnam War that wanted to protest at their school the Vietnam War. So they decided they were all going to wear black armbands to protest, something that absolutely does not disrupt the day. Well, their principal expelled all of them, all the ones that wore the black armbands. By the way, the principal was an ex-veteran of the United States military, and so he saw this as an attack on the military, whereas these students were actually just saying that the war was unjust and we shouldn't be there. Okay? So the Supreme Court gets involved and they overturn that decision by the principal, and they say that you as students have the right to protest so long as you don't interfere with the day-to-day operation of the school. So if you want to protest at lunchtime, for instance, you are welcome to do so. If you want to protest in class, you are not welcome to do so. It is illegal to do that because it interrupts the day of the school. Okay? If you want to protest outside of school, on the road right there outside of the school, when it's not school hours, you are welcome to do that. However, if you're doing it during school hours, then you are skipping school, and that is going to be illegal. Okay? So just know how to protest and know what's legal and what's not. Okay? All right, the next one. This is one of the big 5 court cases that we're discussing. Roe versus Wade. Okay? This is the abortion case. The Supreme Court ruled that a woman's right to privacy, that goes back to Connecticut versus Griswold, a woman's right to privacy under the due process rights of the 14th Amendment extended to abortion. So again, Roe versus Wade declares that a woman does not have to tell anybody but her doctor, and that's it, that she wants an abortion. She doesn't have to tell the father of the baby. She doesn't have to tell her father or her mother. It's up to the woman. Now, this court case was overturned recently. I think it was 2021. And basically, what we said is instead of legalizing abortion for the entire United States, the Supreme Court ruled that that decision should be left up to each individual state. So some states will have abortions, and some states will have laws that prohibit abortions. And that's Roe versus Wade, folks. You need to know that one for the leap.